What do you do if you are awarded um, disability on initial or on reconsideration, but you find that they do not find themselves or provide you with an established onset date that is consistent with the alleged onset date that you put in your application? Now, that is assuming that you knew what you were doing when you put your alleged onset date in your application. And it's quite an analysis as to what it should be, what it could be under the law, and then under what might end up being your medical facts going down the line. All that aside, if you have put down an alleged onset date that you firmly believe comports with when you really could not do any job full time, um, and you were treating for your major impairment and hopefully some of maybe if you have lesser impairments, those as well. If you were treating pretty vigorously then and continue to do so ongoing, there is always the question of, well, I got the award, I don't like their onset, and I have to consider appealing the onset. There's so many tangles to this. First, if you know, the reason why, you have an award, but you do not like the date of onset, the reason you might not like it, let's say it's a year after you yourself stopped working because you couldn't work anymore. So it's a year after your alleged onset date. That's a year of benefits that you would not be getting potentially, right? So if you were getting $2,000 a month, that would be your benefit that month. That's, $24,000 that is being not being allowed to be paid to you because it was found you were not disabled during those months you said you were. So, and sometimes it's 2 years. I mean, it can be, or it's more, maybe you're a 3,000 a month person. It can be a hefty sum of money. And it seems like a lot of, there seems to be, I will say this, possibly a more vigorous approach on initial and reconsideration to provide awards where with a new analysis or a new method of doing it, they are trying to catch things that would otherwise be denied, go to hearing, and then be awarded. Instead, they are potentially, this is just speculation based on some rumors, taking a closer look, finding they're probably going to be awarded anyway. So why don't we award it and pick the date that we find to be most appropriate? Now, of course, other more suspicious minds might say, well, are they picking really the most appropriate date, or are they picking a later onset date while giving the award? So there is the carrot there, the big carrot to make it all go away. Are they picking a later date to save money when really there was enough evidence to have used the earlier date, whether it was as early as the onset date alleged or something afterwards? So this is it's really tough. As most representatives know, and if they don't, they need to learn this fast. To appeal an award when you're considering it only because of the onset date, which is very understandable, there is an entire risk to the whole. Technically, you open up the whole can of worms, and the appealing fact finder, whether it's going to be an ALJ or if you're earlier than that, it would be another adjudicator. They can open the whole thing and then, in theory, make a finding, oh, wasn't fully disabled. I think that RFC was a little bit higher. And lo and behold, there are jobs that person could do with a slightly higher RFC. So it is a risk. Now, I do know of people who have been overturned when they appealed. I know with my clients, I go through the risk and I make them think about it. I don't, I don't accept an answer right away as to whether we appeal because they really need to decide what they're going to do. I think it's also important that you look and find out exactly what the basis was for the underlying change of onset, despite the fact that there's a partial award. What did the adjudicator hang their hat on? Was it I mean, if you know that your evidence was maybe you're going to the doctor with complaints, but there was no diagnostics yet, that might not be a strong basis to appeal. If you did have diagnostics and you've had more later and they all kind of say the same thing and the change in the onset date seems untoward or not clear, maybe it's because you started with one new doctor and they're hanging their hat on that when the evidence was there before, as well as maybe some smoking gun material evident before. If again, it's a case by case basis, but I'm seeing it a lot lately. Getting the awards, and you got that carrot of award in front of you, and everyone hates the process of going through a claim, so they want it to be over. And you kind of, a lot of times it can be you got a bird in the hand versus two in the bush. Keep the one in the hand and just move forward, right? It's a very tough decision, and definitely looking at the evidence of in the record from the time the time that you say you were disabled that they say you weren't, not legally anyway, not evidence wise anyway, is something that's really got to be looked closely at. So I feel like this is what I've been doing a lot of lately, for people that come to me after they've been partially awarded, but they're very upset with and some of them are my clients and some of them aren't, but whether they should appeal or not. And I happen to be a very cautious person. I do have one that has gone to appeal. And that was after, again, the client being fully apprised and, having to make a decision. And then you can, keep in mind, the result could be, we agree with you and we're going back to the old onset. And by the way, if you can find evidence that was not in there that would help prove, let's say, some missing evidence, find it and get it. Unfortunately, that doesn't happen in my cases because we get everything. But in a lot of cases that come to me, there is something missing. That could really help persuade them that it was the wrong date. It could also be that they agree that it was the wrong date, but not as far back as you wish, but better than what you had. So there's multitude of outcomes that are favorable or more favorable than not appealing, but there is always that risk of a complete overturn. And of course, if it's on initial reconsideration, if that happened, you would appeal to an ALJ and continue to treat vigorously, so that no matter what, he's going to find you disabled, hopefully as far back as you wanted, but at least disabled. It's a real heart heavy consideration by claimants of whether to appeal. I do get concerned that so many people won't appeal that there will become a habit of awarding on recon with really unfair dates to deprive people of back benefits. Back benefits, aside from the fact that it's what pays your lawyer, so you don't have to have a fee petition and an outstanding bill, it's what helps people pay sometimes the debt they've accumulated trying to survive while they weren't working and they were fighting for their Social Security disability. So it's a heavy consideration. Anyway, just throwing it out there. I don't know if any of you have had the experience of an award that wasn't as favorable as you anticipated. Did you appeal? Did you not appeal? There's no wrong answer, obviously. So anyway, something to think about if you're in the middle of a claim. What will you do if you get awarded, but it's far, far from when you said you were disabled? Anyway, okay. Have a great night, guys. Bye.